co-presenter, Russ Whittle. Russ is the Vice President of MSP Compliance for Gould & Lamb, LLC, based in Bradenton, Florida. Gould & Lamb, LLC is well known throughout our industry as the national leader in Medicare secondary payer compliance, mandatory insurer reporting, Medicare set-aside allocations, life care planning. It's a good resource for consulting for insurance companies who are still crafting through some of the bizarre programs and procedures that we'll discuss here and you are required to comply with. In Russ's 20-plus years of practice prior to joining Gould & Lamb, I know for a fact that he practiced primarily in the area of insurance defense, represented large insurers and employers in both workers' compensation and general liability matters, which makes him a perfect companion for me today because I know a little something about workers' compensation and subrogation in general. And as we'll see, Medicare set-asides, Medicare set-aside reporting spills over, as of recently, from comp into other areas of insurance, and we'll talk about that. So Russ has developed and supervised the Medicare set-aside and Medicare secondary payer compliance department of a busy South Florida law firm. And welcome, Russ. How are you doing today?
Very well, thank you. Hope everyone can hear me. Happy to be here.
Good, thanks. And we'll have, we're going to tag team this, and I'm going to start. But what's important about Medicare set-asides, because there is a lot of confusion. As insurance professionals, we're concerned with primarily one thing, and that one thing is risk. We insure against risk. We try to minimize risk. Risk management, insurance is one of the key tools of risk management, which makes insurance such an unlikely bedfellow with Medicare set-asides and Medicare potential liability, because there's a great deal of uncertainty in the field of Medicare set-asides, and Medicare uncertainty and risk are two things that don't really go very well together. Whether you're a workers' compensation carrier, a health carrier, an auto carrier with PIP or no fault, everyone has potential exposure, and everyone listening to me at this point may have exposure if Medicare's interests are not addressed and or some of the new CMS, which is the Center for Medicare and Medicaid Studies, reporting requirements are not adhered to. Some of the unintended consequences of even when you're dealing with settling workers' compensation claims come up to bite us in the hind parts, because if we settle a workers' compensation claim as part of a third-party settlement, which is very, very common, you may have some liability if there is Medicare liability out there. This is true whether you commute a workers' compensation settlement in states that allow commutation, or whether you do a dollar contract to close out medical as you would in Illinois and some other states. In any of those situations, the workers' compensation carrier has some obligations to the federal government, or it can be looking at some potential future liability. When you settle a third-party claim, the MSAs have an effect on the lien and the credit, and there are a number of questions that remain unanswered. I think, I know Russ is certainly one, and you may have probably two of the best people presenting this webinar to provide you with answers to some of the questions that plague our industry. Unfortunately, Russ and I aren't going to have answers to all of the questions. It's not because we don't know them or we haven't looked them up. It's because there literally are no answers. There are just best practices in many cases, and there are suggestions and there are tips. And we will be going through those in those areas where there are really no concrete answers, only questions. Even with small subrogation claims that used to be rote, you send a demand letter, you settle a claim, we are now having issues and problems with reporting requirements, and even with arbitration of claims involving MSAs, where you have two members of ARB who want to arbitrate a claim, and now suddenly there's the potential for Medicare involvement. What happens if both members of both insurers are members of ARB, but CMS the federal government is not. If we win, can Medicare make a claim against us? These are issues that continue to plague us. I will be going through a short history of Medicare and some of the legislative archaeology that brought us to our current status. From the 1980 Secondary Payer Act to 2003 to the Medicare Prescription Drug Improvement and Modernization Act. We're going to be going through how we got to where we are today, because I think that's instrumental and very illustrative of not only where we think we may be going in the future, but how to handle some of the claims that we have today. So again, the unknowns of Medicare and the risk-benefit analysis that many insurers are having to undergo in order to avoid potential liability, I think are keys to handling some of these Medicare set-aside issues. The history of Medicare and the Medicare Secondary Payer Act is an interesting and actually quite an amazing story. Medicare is a social insurance program which is administered by the U.S. government. It provides health insurance coverage to people who are age 65 and over or who meet other special criteria. This program is mammoth, and the word Medicare is not only in the insurance profession but in political science and current events. I mean, the status of Medicare, the health of the Medicare system, its solvency are all issues that concern us. And those concerning issues are primarily the reason why the insurance industry has been dragged into this, because the federal government is trying to prevent fraud and waste. And back when the Social Security Act of 1965 was signed into law by Lyndon Johnson, on July 30th, 1965, and at that bill signing ceremony, President Johnson enrolled former President Harry Truman as the first Medicare beneficiary and actually presented him with the first Medicare card, and Bess Truman got the second Medicare card, just as a bit of trivia. The Medicare Trust Fund is said to, it will be exhausted by 2017 unless some rather stringent measures are made. Based on the, I have Fox News on in my office, and I saw a 16% approval rating for Congress today, and I just shook my head and said, you know, I'm not quite sure that Medicare will be handled by 2017, but this is actually 2 years earlier than the original projected date under which the fund will be exhausted, according to the annual report by the Medicare trustees. So each year, the trustees of Social Security and Medicare trust funds report on the current projected financial status. And because of these difficulties, there was a lot of political pressure to protect and preserve the Medicare Trust Fund. And to reduce Medicare costs, Congress enacted a collection of statutory provisions in the 1980s called the Medicare Secondary Payer Act. Now, this is also known as the MSP. So if Russ or I refer to MSP, we're referring to this act which was passed in 1980, which was largely in recognition that workers' compensation carriers are the primary source of medical insurance coverage for workers injured on the job. If someone is injured on the job and work comp covers it, you have an interesting situation. They are covered by workers' compensation, but if they are Medicare eligible or are even receiving Medicare, you now have double coverage. You have Medicare paying and or maybe obligated to pay, but you also have workers' compensation. So the Medicare Secondary Payer Act in Section 1395Y made Medicare a secondary payer to not only workers' compensation, but also to group health, auto, liability, and no-fault insurance. This didn't happen overnight. This section provides that in order to recover payment under this subchapter for an item or service, quote, the United States may bring an action against any or all entities that are or were required or responsible directly as an insurer or self-insurer, as a third-party administrator, as an employer that sponsors, contributes to a group health plan or large group health plan or otherwise, to make payment with respect to the same item or service or any portion thereof under a primary plan. We are the primary plans. So when Russ and I talk about a primary plan, we're talking about a term that the U.S. government has used in the United States Code to refer to us, the insurance industry, who ought to be responsible. And basically Medicare is saying we've had enough. We're not going to pay where private insurance should pay. There are a number of cases which came down, and Medicare liability and potential liability evolved over a number of years, not only with federal statutes, but with case decisions and, drum roll, administrative memos. And this is interesting because, and Russ may talk a little bit about this, but there are a number of CMS memos which were authored by people within the department, the Medicare department. And when we talk about CMS, we're talking about the Centers for Medicare and Medicaid Services. Just think bureaucracy. Think huge. And that's what we're talking about when we talk about CMS. It's basically Medicare. And so CMS actually issued some memos which caused a great deal of consternation, uncertainty, and potential liability within the insurance industry. And that provides all kinds of questions about notice and how fair is this to the industry to have potential liability and have to incur all these costs with new reporting requirements and et cetera. But that's a little bit beyond the scope of this this webinar. But in 2003, the Fifth Circuit, which is Texas, Oklahoma, Louisiana, and some of the southern states down there, issued an opinion in which Medicare sought to recover from a product liability suit. This is a case where the government, the CMS, tested the power of its super lien because the Medicare Secondary Payer Statute authorizes Medicare to make conditional health care payments when a primary plan, remember that's us, has not made or cannot reasonably be expected to make payment with respect to an injury promptly. So basically, the federal government, Medicare, will pay if they're supposed to pay, but if there's an insurer, us, a work comp carrier, or any of the other carriers I mentioned, we are supposed to be the ones primarily responsible. And in Thompson versus Getzman, Medicare tested the power of its super lien by trying to expand the meaning of the term self-insurance plan in an effort to extract reimbursement out of a product liability suit settlement. So plaintiff sued product manufacturer, case went into litigation, and there was a settlement in this case, and suddenly Medicare appeared on the horizon saying, hey, you owe me a bunch of money because we made these benefit payments and it wasn't taken care of. This Fifth Circuit suit was dismissed because a settlement agreement was held not to be a self-insurance plan under the Medicare Secondary Provider Statute. And although the term self-insurance plan isn't defined within the statute, the Fifth Circuit gave the term its ordinary meaning and said that to be a self-insured entity, a self-insured plan, an entity would have to engage in the same sort of underwriting procedures that insurance companies employ. Because they didn't, the case was dismissed. Not long afterwards, the 11th Circuit, now we're talking Florida, Georgia, Alabama, the 11th Circuit down in the southeastern part of the United States dealt with a case and disagreed with the Getzman opinion regarding what it takes to have a self-insured plan. This case, Baxter, arose out of a $4.2 billion breast implant settlement. And the government, the Medicare, intervened against the manufacturers of the silicone breast implants and the escrow agent for the litigation settlement fund, seeking to recover the costs of medical care and treatment related to some 81,000 plaintiffs in that case. This court now, the 11th Circuit, ruled that in order to have a self-insured plan within the meaning of quote-unquote primary plan as defined in the MSP statute, there must only be some arrangement, oral or written, by which an entity assumes legal liability. So the court said any payment Medicare makes is secondary, and anybody who is primary could be liable to Medicare. So we had a lot of concern arising out of that case. In 2003, not long after U.S. versus Baxter, the Medicare Prescription Drug Improvement and Modernization Act was signed into law by President George Bush. In this piece of legislation, it further spells out Medicare's recovery rights and their enforcement power, and actually did a lot of cleaning and basically put the U.S. versus Baxter decision on steroids. It said that all payments made by Medicare both before and after settlement of a workers' compensation claim are considered conditional, and repayment is required by the MSP Act. This act now provides for a private cause of action against, quote, any entity including a beneficiary, provider, supplier, physician, attorney, state agency, or private insurer, close quote, which have received any portion of a third-party payment directly or indirectly, where those funds should have covered Medicare expenses. So they can reach in and take attorney's fees. They can any part of a settlement, no matter who it's allocated to or how it's allocated. This statute gives them a rather strong ability to come in even after the fact, long after the fact in some cases, although we'll see in a case that's coming up that there are limits to that, and print liability on innocent insurers who are just going about the business of adjusting claims and settling claims. In 2009, a few years later, a case out of West Virginia was filed involving a plaintiff's attorney who settled a personal injury case for $25,000. A rather small case. The plaintiff was a Medicare beneficiary for whom the CMS had paid $22,500 in medical services. So he received almost $23,000 in Medicare benefits, and the plaintiff settled a personal injury case for $25,000. Prior to this settlement, Medicare had agreed to accept a little over $10,000 of the $25,000 settlement. Russ will tell you later on that it is possible to negotiate with Medicare. I mean, they are big and they are bad, but they are still human, kind of. And they are reasonable because they have limited resources too. But in U.S. versus Harris, the plaintiff's attorney apparently didn't distribute CMS Medicare its money within the required 60-day period after a settlement, and CMS upped the ante to $11,367, and they didn't seek double pay or other penalties, which Russ will talk about in a moment, that we have to be aware of. But the court held that the Medicare secondary payer statute gave the government a right of recovery on these conditional payments, and specifically said that anyone who benefits from a CMS payment could be liable, including any supplier, physician, attorney, state agency, or private insurer. What's so amazing about this case, and the reason we included it in here, is that it reflects the level to which the U.S. government will stoop to chase after a small figure against the plaintiff's lawyer because the CMS did not get its full recovery of medical services payments. Lawyers are concerned, and they should be, about this case, and this can actually work to our advantage. Toward the end of the webinar, when we start talking about recommendations and tips, you'll find that this can actually work to our advantage. The U.S. versus Stricker case is an interesting case in which the U.S. government sued chemical companies, insurers, and plaintiffs' attorneys involved in a $300 million breast implant settlement. Abernathy versus Monsanto was one, and there was another companion piece of litigation. But the plaintiffs' attorneys distributed the money without reimbursing Medicare. CMS sought reimbursement for double the provisional payments that they had made. They filed suit a little more than 6 years after the Abernathy settlement. The defendants moved for dismissal based on the statute of limitations, and that on September 13th of this year, the judge finally dismissed those claims as being barred by the statute of limitations. So what was interesting about that is that he ruled that this case was barred by the statute, and in her ruling, Judge Karen Boudry offered a lengthy explanation as to how the Federal Claims Act collection statute of limitations applies to these cases. But in the end, she ruled that the government's claim against the corporate defendants were barred by the 3-year statute of limitations, and the government's claim against attorney defendants were barred by the 6-year statute of limitations. So it's a rather significant case in as much as it really shows the lengths to which the government will go, but they have limitations based on time. Then in our walk-through history here, there is the Medicare and Medicaid SCHIP Extension Act of 2007, known as the MMSEA. Russ will refer to this as Section 11, and when he gives you some of his wisdom here in just a minute. This is the section that has to do with the mandatory insurance reporting. Originally, only workers' compensation carriers were primary carriers under the MSP statute. Now, however, the law has been expanded to include group health, certain non-group health plan arrangements such as liability insurance, including self-insurance, including no-fault insurance. These are all now primary payers. And any entity that carries its own risk with respect to tort liability, including the risk of having to pay a deductible, may be considered a primary plan and subject to MSP requirements for reporting once its obligation to make medical payments has been, quote-unquote, demonstrated. Therefore, the MSP statute is now broadened under this MMSEA to impose liability on any entity that settles claims with potential Medicare beneficiaries. This could be a product manufacturer, a negligent tortfeasor. They're all considered primary payers under the Act, and that's sort of a new development. One of the new developments, now let Russ tell you about this, has to do with the deadlines and for Section 111 reporting, which I think is going to be relevant to third-party cases. But Section 111 stipulates the required submission of claimant status by or on behalf of liability insurance companies, no-fault insurers, and workers' compensation carriers if a claimant is determined to be Medicare entitled. Now, Russ is going to pull back the curtains on these new requirements. I've gone through the history. But the question is that we all have to be asking is, how do these new reporting requirements and these rather obfuscated and confusing potential liability statutes affect subrogation? We're going to find there aren't as many clear-cut answers as we'd like in this area, and for the time being, we're going to have to settle for some best practices and tips. But I'm going to turn this discussion over to Russ, who will start with this new and confusing concept of mandatory insurance reporting to CMS. Russ?
Yes. Okay. I'm hoping everyone can see my screen. Hold on a second.
Yeah, we're going to get up Russ's webinar. There we go.
Okay. I'm hoping everyone can see my screen. Thanks, Gary, for that. Just a couple of points I wanted to make with respect to Stricker. I think all of us in the Medicare industry waited very patiently for Stricker to come out, and in fact, we're very surprised when the judge dismissed the Stricker action just because of the amount of money that was really at issue. The government was seeking to recoup about $70 million in that case on a $300 million judgment. The other shoe really hasn't dropped with respect to Stricker at this point. We expect the government now to go ahead and appeal it. Important for our purposes, I think, on the call, the judge really drew the distinction between what the triggering event was for purposes of MSP conditional payment recovery, and that was the actual approval of the agreement, the settlement agreement by the judge, as opposed to the disbursement of funds. So Stricker case is really very important for everybody, sets out, at least as far as we know, what the statutory limitations period are or is on MSP, again, as far as we know it at this point. So it's important. I encourage everybody to take a look at it. Let's talk about MMSEA, and that's the Medicare, Medicaid, and SCHIP Extension Act. SCHIP refers to State Children's Health Insurance Program. The states got together, and the legislature, in their wisdom, decided that all states should be able to provide a low-cost health insurance program to children. The only problem with that, or one of the many problems with that, I guess you could say, was that there was no funding for it. I think what the federal government did was they looked back across their potential enforcement mechanisms, came across the Medicare Secondary Payer Act, and decided that that would be a great source of funds. Say what you will about MSP. Most people say that it's a Medicare Act. I firmly believe that it's a tort reform act because it allows the government to attach, in some respects, tort recovery with respect to conditional payments to fund the State Children's Health Insurance Act. It is Section 111 of the MMSEA that we're interested in. And basically, MMSEA has put into effect the mandatory insurer reporting requirement. What that means is that all settlements, judgments, or awards that have a future medical component and a conditional payment component are required to be reported to Medicare so that they can take a look at that data and make a determination as to who acted in good faith with respect to their interests. We talk a lot about what Medicare's interests are in cases, but Medicare has now, through MMSEA, gotten the mechanism to take a look into each of your files to determine whether their interests have been taken into account. Section 111 requires insurance companies, RREs, responsible reporting entities, to transmit data to Medicare so that they can review that file to make a determination as to whether things were done properly within that case. They're going to review it to make sure that their conditional payments were taken into account and that there's a future medical component and that their interests were taken into account in that respect. In liability, it's a little bit fuzzier, but in workers' comp, we've been dealing with it for about 10 years with respect to the future medical component. It's important to point out here, I think, that in any case, there are two distinct concerns. One is the conditional payment concern, which is those dollars that were expended conditionally by Medicare, assuming that a primary payer would pay, as Gary discussed. And the other is that future medical component, and we'll talk about that. And of course, we're talking about the MSA requirement there. So when we're dealing with this information, you want to put it into two buckets. One is the conditional payment bucket, and the other is the future medical component. Now, Section 111 is going to require reporting on both of those grounds. Certainly, the government's going to be able to make a determination as to whether conditional payments were resolved, but they're also going to be looking at whether that medical component in the future was resolved as well. There are really hefty penalties with respect to failure to report. It's $1,000 a day per claim, $365,000 per year on any given claim if these things are not reported to the federal government. By now, almost all of the major carriers and responsible reporting entities have something in place to report, and in fact, they've been reporting. The penalties are at this point kind of not quite very well fleshed out, because there's a real question as to whether the government is actually technically capable of receiving the information that they're requesting. But we expect to see penalties shortly for people who, or for entities that aren't able to comply. The Secretary of Health and Human Services makes a determination as to the mechanism of the reporting itself. And the important point for all of us on the call is that Medicare now sort of just opens everyone's files and takes a look into them to determine whether their interests have been served or not. Oops, sorry about that. Let me get back to where I'm supposed to be. Okay. Some of the more technical aspects of this, it's somewhat complicated with respect to what has to be reported, but essentially it affects all liability, no fault, self-insured and workers' compensation claims. Any claims that have a medical component to them. Any claims where there could have been ongoing responsibility for medical care, such as no fault or workers' compensation, or where the primary payer should have paid based upon a liability determination. Now, the time frames have been somewhat confusing, and they've been consistently pushed back. Now, all claims with respect to liability, no fault, self-insured, and workers' comp claims have to be reported as of January 1st of 2012. Claims that have been pushed back over the past year have only been those claims that require a reporting of the total payment obligation to a claimant in liability. As we sit here today, as of January 1st of 2011, workers' comp claims, no fault claims, self-insured claims where responsibility for medical care has been established are all reportable as of January 1st of 2011. Total payment obligation to the claimant where no ongoing responsibility for medicals have been established is now reportable as of January 1st of 2012. So there's been a sort of a year's delay built into what we expected to see with respect to mandatory insurer reporting. However, all other claims are reportable as of January 1st of 2012.
Hey, Russ, this is
Yeah.
Gary. Technology is wonderful, and how we can get 200 and 300 people together for a webinar like this. It does have its drawbacks. As we thought. There are a couple of people who are only seeing my screen, so I took the screen back.
Okay.
And I am on the SCHIP reporting section 111.
That's fine.
Slide.
Okay, and I'll tell you when.
Slide number 9.
Okay, great. So just to get through with this slide, I mean, basically we're talking about a situation where all claims as of January 1st of 2012 are going to be reported. As of this point, all claims that don't have a total payment obligation and don't have an ongoing responsibility for medical component to them are reportable as of January 1st of 2011. So what you really need to do with respect to 111 reporting is make a determination as to what that claim requires and what it includes. If you have already accepted ongoing responsibility for medical care and there's a conditional payment component, it's a reportable claim. If you've not accepted medical responsibility in a claim and you're going to settle it under a total payment obligation, then you have until January 1st of 2012. So the deadlines have moved, the target has moved a little bit, keeping in mind that conditional payments are certainly still something that we have to be aware of under MSP. All right, Gary, we'll go to the next one, please. Again, remember, it's a $1,000 a day penalty. NGHP means non-group health plan. MIR is mandatory insurer reporting. So what's happened over the past year is that the CMS, the Centers for Medicare and Medicaid Services, Medicare for all intents and purposes, has been accepting data from January 1st of 2010, obviously of this year. We've been testing with CMS to get them to accept data from our responsible reporting entities, and they've given us an opportunity, and all our is an opportunity to work out the bugs in their reporting system throughout this entire year. So obviously those of us on the call, our clients or those that we deal with on the carrier side, should have a reporting solution in place at this point. The difficulty of this information for reporting purposes is there's 180 plus fields of information that have to be filled in by an adjuster or a responsible reporting entity. Obviously that requires a lot of the carriers and RREs to go back and retool their entire system to be able to capture this data. Sometimes there's questions about whether this is actually discoverable information. The first live report began January 1st of 2010 for that first quarter ending March 31st of 2010. That was when the original penalty period was to begin, because one of the original dates was April 1st of 2010. That was pushed back to, again, January 1st of 2011, and now for qualified claims, January 1st of 2012. So those claims, again, with ongoing responsibility for medical, have to be reported. TPOC amounts, total payment obligations to claimant amounts, got switched. There was a no penalty provision if they settled before October 1st of 2010. Again, now that's been pushed back to 2012. So you can see that they've been changing their reporting requirements. It's a moving target here with respect to a lot of the mandatory insurer reporting, because they're not technically capable of handling a lot of this data. Everyone at this point that is responsible to report should certainly have in place what their reporting solution system is with respect to both liability. Workers' comp, again, has been a lot better about this because we've been dealing it for a lot longer. Again, MIR, mandatory insurer reporting, is going to require that conditional payments be reviewed and that the future medical component be reviewed as well. Gary, can you go on to the next one, please? What is an SCHIP, again, State Children's Health Insurance Plan compliant claim? Well, what does it require? It really requires the primary request. The primary inquiry in any of these cases is, what is the eligibility status of the claimant or plaintiff? Obviously, without the eligibility status being established, it's very difficult to tell whether there's a mandatory insurer reporting requirement under 111 or not. Therefore, what we do is periodically request from Medicare information on a person's beneficiary status. Each claim is checked. CMS says on a quarterly basis. The reporting periods are quarterly. We send them a query called a Medicare query function, which includes what they call the Big Five information, and that gets a response from Medicare as to whether this person is eligible. Once eligibility is established, you then have to make a determination as to what you're going to do with respect to that first pre-settlement component, which is conditional payment, and then depending on what type of claim you have or what your risk exposure is, what you would be doing on the other end on the future medical component. So Medicare eligibility has to be checked in every case. You then make a determination as to what you need to do with respect to conditional payments, and then what you need to do with respect to future. Keeping in mind that eligibility is everything. Without an eligible claimant or plaintiff, reporting requirement is not triggered. There is one caveat that I should say. A lot of cases, somebody is not Medicare eligible at the time that you begin your claims handling, but at the time of your settlement, judgment, or award, they've become Medicare eligible, which means that the reporting requirement or the Medicare query function becomes pretty significant to your case. All right, Gary, can you go on to the next one, please? What is a compliant settlement, judgment, or award under state children's health insurance, the mandatory insurer reporting requirement? Well, obviously, again, that beneficiary status is step one. If the person is Medicare eligible, the question is whether conditional payments have been made by Medicare, whether Medicare has made payments based upon their determination that a primary payer is responsible. Those have to be resolved in every case. We can talk about liability as opposed to comp and things of that with the future medical component, but conditional payments are there in every case. And again, making a determination as to whether an allocation is necessary is based upon your case. The last step to any case after making a determination that conditional payments are resolved, whether an allocation is appropriate, is again that 111 reporting and the technical solution to get that completed. But that is basically what has to happen in every case after eligibility is determined. Gary, can you go to the next one, please? Okay, now here's the hot button. Whether liability MSAs are necessary, and I debate this virtually every day in my job. There is no technical requirement that a set-aside be done in a liability case. There were those that argue that there's no CMS guidance on that. I don't necessarily agree that there's no guidance. There are what's called town hall meetings where CMS gives us their indication of what they think the statute says. Based upon what Barbara Wright has said in 3 or 4 of the town hall conferences, and actually most recently, CMS, the Centers for Medicare and Medicaid Services, certainly believes that the MSP is broad enough to require a future medical component in liability claims. While they don't have the same hoops and technical responsibilities to jump through that workers' comp has, CMS firmly believes that the statute should be read very, very broadly and that Medicare's interest would include the future medical component. They do have mechanisms in place to review set-asides in liability cases depending on the regional office and their jurisdiction. They have advised us personally that they typically take a look at cases over $250,000 where eligibility status has been established on behalf of the injured person. With Section 111 reporting, we're talking about cases being open to Medicare scrutiny once they are reported. It seems to me a little incongruous to suggest that they're going to be gathering data on workers' compensation and liability cases if they don't intend to suggest that the MSP with respect to future medical component applies to liability cases. So while there is no specific guidance granted, while there is certainly no statutory requirement and suggestion, all indicators are that they believe, CMS believes, that liability claims would qualify under the MSA analysis. And whether that's true or not, I typically advise my clients that they're not certainly wanting to be the first ones that are in the way of Medicare making a determination that something should have been done on a future medical component of a case that hasn't been done. Can you go to the next one, Gary? Briefly, we're going to talk about Medicare set-aside. I don't want to spend too much time on this, but I think that for our purposes, what an MSA is technically is a fund that is earmarked for the future medical component of a case. It includes Medicare-covered expenses only that are secondary to an injury or accident. It is an interest-bearing fund to be administered by either the injured worker, a professional administrator, or some hybrid of those. But technically, that's what a Medicare set-aside is. Again, it includes funds to cover the future Medicare-covered expenses secondary to an injury. Can you go to the next one, Gary? And then we're running short on time. You should take a look at 42 CFR 411, which is the Medicare secondary payer regulation on this information. Again, as Gary had said at the top of our show, The situation here is that Medicare is trying to make themselves always a secondary payer. That certainly applies to conditional payment situation. The question is whether it applies on the other end of the medical component. I would argue that CMS thinks that it is, that the MSP is broad enough to suggest that in fact there is a medical, the future medical component is also involved in the analysis of whether Medicare will become a secondary payer. Again, what's important for us is that primary payers include workers' comp carriers, liability carriers, auto no-fault, Longshore and Harbor Workers Act, and Jones Act carriers. And again, what we're looking to do here is to analyze whether the regulations would require the broad reading that CMS gives it. The State of the Union, I guess, at this point is that, again, they're reading it quite broadly to suggest that it does apply across the board. And of course, Section 111 is going to make all of those files transparent. Next one, please, Gary. Gary, can you go to the next slide? Or there we are. Great. So to comply with Section 111 of 2007, we've talked about what the technical requirement is. Certainly, it's going to affect us across the board with respect to insurance claims. It's going to require that reporting to Medicare involving settlements, judgments, or awards. Carriers are certainly going to want to avoid that $1,000 a day penalty. How it's to be at this point administered is anyone's guess because, again, Medicare may not be technically capable of handling the data. The testing itself began in January of this year. As of January 1st of 2011, claims are now reportable with the exception of those total payment obligations to the claimants that didn't include ongoing responsibility for medical. So we're getting right down to that point where Medicare is going to have all of this data. They are seeking, make no mistake about it, to financially back the Medicare system. As Gary said, we're talking about a system that will be bankrupt, at least Part A, by 2017. They're looking at Section 111 as the mechanism to guarantee themselves about $5 trillion return from tort cases. So that's the background here, and that's what we're looking at. All right, the next one, Gary. And I think, as I just said, basically, they're looking to get back their money. Again, separating this into really two buckets here. Conditional payments are a reality in every case where there's a primary payer. The question about what you want to do with respect to that future medical component is debatable at this point. Again, my feeling is that if the statute is to be read broadly, Medicare's interest would include that future medical component. I may be convinced otherwise in any given case. Let's talk about the penalties associated with Section 111. Any responsible party, as Gary said, and as the Harris case illustrates, is in Medicare sights with respect to getting penalized here. With respect to the conditional payment aspect of it alone, and that's what we're discussing with here, the conditional payments can be recovered based upon twice the amount of conditional payments plus interest. When you're seeking to determine exposure in any given case where there's a conditional payment situation, if they're not resolved either in the course of your settlement or directly to Medicare during the course of your negotiation, the measure of damages is double damages plus interest. In a liability context, CMS may refuse to recognize any settlement that they don't believe took Medicare's interest into account. So, for instance, if you settled for $100,000, Medicare would say, we're not going to be responsible for any medical care in this case until $100,000 is expended. Probably the first line of defense that Medicare would take, based upon a determination that something was settled without their knowledge or their sign-off on it, is that the benefits to the beneficiary would be discontinued. Obviously, that ends in the knock on the claimant or plaintiff's attorney's door, which goes back to the primary payer. There is a private cause of action that's available under the MSP on conditional payments. which allows essentially that plaintiff to use the full force and penalty provision of the MSP against the parties that fail to protect the interests of the injured worker. So, we're getting to the point where lots of cases are coming out on these issues, and it's being fleshed out with respect to conditional payments. I write pretty extensively about the cases that do come out on our website if you're interested in checking that out, but it sort of illustrates what these issues are at this point and what the pain points are in handling some of these cases. Okay, we'll go on to the next one. Gary, I think that's yours.
Let me see.
Sorry about that.
What slide number, Russ?
It says 19 on the bottom, I believe. The next one. There you go.
There must be a delay because this was up, and just as an apology, I think there are a few people, including me, every once in a while, who Russ, you're interrupted with a little bit of static, and I think we figured out that that's you're talking through your computer, correct?
Correct.
Yeah, okay, and I'm on the phone with a headset, and I think that might be the problem for future seminars. I think we'll get that ironed out, and we apologize for that, but for most, we can hear most of what you're saying.
Okay, great.
Okay, when we're talking about identifying MSP exposure, Russ, do you have slide 19 up?
Yes, I do.
Okay.
Right. These are the workers' compensation thresholds. So the initial inquiry in any case, liability or comp, is whether future medical portion of your case is being closed or limited. The workers' comp thresholds are fairly simple. Obviously, Medicare eligibility is the first inquiry, even if it is as it is with conditional payment situation. If someone is Medicare eligible and they're settling their case for a value of over greater than $25,000, CMS is going to require or seeks to require you to do a Medicare set-aside. That's a Class 1 beneficiary, somebody who's Medicare eligible at the time. Class 2 beneficiary is based upon a reasonable expectation test. Again, this is limited to workers' compensation. If somebody is going to become a Medicare beneficiary within 30 months and you're settling your case for over $250,000, CMS would like to see an MSA done at that point. And the last class of beneficiary here is whether somebody who doesn't meet those first two classes really is considered a risk here or a Medicare risk. These are our case thresholds. They're not set in stone. These are what CMS will tell you that they want to see under these circumstances. But what it really is a test of good faith. And make it, if you're a Medicare beneficiary and you want to hold your settlement under $25,000 not to be reportable, CMS may look at that case and say, look, you settled for $24,999, and we consider that still inappropriate. We still think that is a case that requires an MSA. The same holds with respect to the $250,000 requirement. So really, since there are no safe harbors here, every case has to be determined on its own merits as to whether Medicare's interests have been taken into account. Go to the next.
Now, with regard to those of us who deal with subrogation, I think, unfortunately, at the end of this webinar, there'll be an evaluation form. Yeah, Russ did a good job. Gary did an okay job. I wish there was another checkbox on there. How did the federal government do? Because the questions that you may have, some of which we're not simply capable of answering with any certainty, are as a direct result of the uncertainty in the current state of the law. For that reason, if you are dealing with subrogation, some of the recommendations we have are, number one, determine in any settlement, if you are settling or resolving or disposing of or tweaking or affecting in any possible way future medical care, an MSA may be necessary. Many carriers have internal guidelines as to how much risk they will assess, how much risk they will accept, what the benefit of it, what the cost-benefit analysis is. But the simple truth of the matter and the fact of life in our business is that some players are going to want Medicare at the settlement table. I don't have any better advice than in those situations you just have to deal with it. You can't send them a case site or have Russ call them and make them feel better about it, because there aren't those things to make them feel better. You have to use common sense and a good faith approach to determining whether the settlement amount was based on some specific recognition of the cost of future medical treatment. If they're not treating, if there's no likelihood of future medical care, that should be taken into consideration. But if there is, this is going to have to be adequately preserved to take care of future medical needs. And that can be done in a number of ways. I mean, MSAs are the rock-solid way, once they're approved, of making sure that you will have no liability. But an MSA is a long road to hoe. I mean, there's several steps that Russ has talked about. It can be expensive, and it is, above all, time-consuming. So it really throws a monkey wrench into the entire litigation world because of the uncertainty that we have. Subrogation professionals should try to express in their files the care that they have taken in preserving the handle of future medical needs, the calculations of the settlement and the settlement documents. Take steps to set aside and preserve those funds which are necessary to take care of future medical needs, as in a medical trust. Urge the plaintiff's attorney, who may not even be aware of some of this potential exposure in a case in which the liability carrier is insisting on an MSA, and I've had this in many, many cases, to realize that he has some exposure too, and he might be better off taking some money and putting it aside in a medical trust. I would advise to err on the side of caution. And if there is any doubt, or if it's a coin toss and there is some significant dollars involved, err on the side of caution and submit your set-aside calculation to CMS for approval. After you've done a few of them, it's not as onerous as it seems. There are great companies like Gould & Lamb around to help you do that, and who make it very painless. The only pain is sitting and waiting and looking as your calendar ticks by, waiting for somebody in government to approve this. There's a story I tell to a lot of the plaintiffs' attorneys who are just, and a lot of them are from the old school, and they're just totally upset and almost in denial about how government can throw this much indecision and this much uncertainty into a field where we are used to dealing with certainty. I tell this story about a boy named Chuck who grew up in Montana as a young boy, and he bought a horse from a farmer for $100. And this farmer agreed to deliver the horse the next day to Chuck. Well, the next day the farmer drove up and said, "Sorry, Chuck, I have some bad news. The horse died." Well, Chuck said, "Well, then give me my money back." And the farmer said, "Well, I can't do that. You see, I spent it already." Chuck said, "Okay, well, then just give me the dead horse." Well, the farmer said, "Well, what are you going to do with a dead horse?" And he said, "I'm going to raffle him off." And the farmer said, "You can't raffle off a dead horse." And Chuck said, "Sure, I can. Watch me. I just won't tell anybody he's dead." So a month later, the farmer met up with Chuck again and said, "What's with that dead horse?" And Chuck said, "I raffled him off. I sold 500 tickets at $2 a piece and made a profit of $998. The farmer scratched his head and said, "Didn't anybody complain?" Well, Chuck said, "Yeah, just the guy who won, so I gave him his $2 back." And Chuck has now grown up, and he works for CMS, and he approves Medicare set-asides. That's sort of the nature of what's going on behind the curtains with government. And we as subrogation professionals have to identify liability and responsibility to report to and make good with CMS for Medicare responsibility. It's possible to have an agreement between the parties indicating that liability is in dispute and questionable. And why does that help, you might ask? Well, part of the reason is Medicare will look at these things, and they realize that cases with uncertainty and uncertain liability are being settled. In fact, there's a question here. We're going to get to questions in just about 60 seconds. The question came in about, well, what happens if you have uncertain liability and you settle for 50 grand and there's a 50 grand Medicare interest in it? Well, Medicare will take those things into consideration, both for past super liens and for future potential exposure. So always in your agreements indicate that liability is in dispute, future medical is in dispute, it's being debated. Again, many carriers have internal guidelines, but much is still very, very uncertain about this. Determine whether your settlement is a reportable event under Section 111. And, you know, what's a reportable event? Well, Russ talked about some of the requirements. If reportable claims are those in which an injured party is eligible for Medicare. It's a person who can become a Medicare recipient based on either reaching age 65, being eligible for Social Security disability for 24 months or longer, end-stage renal disease. I've never really even figured out how that got in there, but if determine whether your settlement is a reportable event, and determine whether funds have been dispersed for medicals, and if it resolves medical issues as a lump sum. This is particularly important in cases in states where you can lump sum or commute medical in a work comp claim, and as part of the third-party settlement, maybe you're taking less on your lien back, your work comp lien, but you're closing out medical. Well, suddenly you've got some concerns if you have a reportable event. Determine appropriate release language. Indemnification language is recommended. Identify the primary payers. Identify liability and responsibility, and always, if possible, allocate the amount of damages that has to do with future medical care. Before we start answering questions, I want to just remind you that as dismal as this looks, because risk equals fear in the minds of insurance professionals, this also represents an opportunity for subrogation professionals. Medicare set-asides, Medicare law, especially if you know more about it than the average plaintiff's attorney with whom you're negotiating, can actually be an effective negotiating tool. I've been very successful in getting some wonderful recoveries just by offering to have the insurance company be the one who goes out and submits an MSA and pays for it, but includes the MSA dollars in the lien. And plaintiffs' attorneys have been amazingly receptive to that proposal. So you can offer to pay for and set up an MSA in exchange for other good and valuable consideration. Russ, we've got some questions here that I thought I'd go through. There are some technical questions here that Russ and I will answer via email because they look rather lengthy. Sharon has asked, we've had Medicare for how many years, and they are just now recently getting interested in getting reimbursement, question mark. Let me grab that one and just say, yeah, this is very, very political. As we've discussed, Medicare is on the ropes politically, no matter which side of the aisle you're on politically. This Medicare is the third rail, which nobody wants to touch. And this is sort of a poor man's way of trying to fix Medicare. I mean, Russ mentioned the dollars that will be saved in this quasi-tort reform sort of measure, and I think that the reason we're first now getting into this stuff is because politicians are desperate, because they see the train at the end of the tunnel coming our way, and they're having to take steps to fix it. Russ, Don asks, I feel a lot of questions from several different platforms. He's got a few questions here. When is reporting required on denied claims? In other words, there's no payments. And does present value of future obligations go past the 20 years?
On denied claims, it's still considered a settlement, judgment, or award. So it's a reportable event. If you are now, if it's a claim where there's a total payment obligation to the claimant, it's going to have to be reported as of January 1st of 2012. If it's a case where medical benefits were accepted prior to that point, it's immediately reportable January 1st of 2011. But the denial doesn't change a reportable claim. Just because there's a denial, that doesn't mean that the grounds, as far as Medicare is concerned, are good. CMS will not be bound by the parties' determinations of liability. They would want an order or a verdict of some kind. So a settlement, judgment, or award that pays out a settlement to a claimant that's a Medicare beneficiary is a reportable occurrence. I'm sorry, Gary, what was the other half of that question?
Does present value of future obligations go past the 20 years?
Not certain where where that.
I'm not either.
Value concerns are expressed in for purposes of an MSA without any inflationary factor involved. So what we do is on an MSA project out the value of future medical care without that inflationary bump, so to speak, and that's what's accepted by CMS, which may be another disconnect here, you know, okay, in claims handling.
Another question by Don. What if we get CMS approval and it is not enough? Does CMS come back after the indemnity settlement or the primary payer? That's the one nice thing about this, despite the onerous steps necessary with reporting and even the obtaining of a CMS, an MSA. Once CMS does approve it, it's a get-out-of-jail-free card. Because we can't look into the future. We don't know whether somebody's going to fall into a medical relapse, and future medicals are going to be quadrupled. And I guess, Russ, that Medicare is simply saying, look, we're going to make a good faith effort at this. We might get it wrong, but if we approve it, you're good to go, correct?
Correct. Essentially, their approval of a number means that they've had their experts, for lack of a better word, determine that an allocation has been appropriately made. Once they accept that, I've seen it, but it's very exceptional that they would go back and change it. But basically, they then are waiting for the injured worker on the other end to apply those set-aside funds to future medical care, and they assume that they won't be bothered with a bill for medical services until that money is exhausted properly.
Okay, question from Heather. Will you be discussing Medicare Advantage plans and whether or not they can make a claim for a set-aside?
Yes, I will. Let me say a few things about Medicare Advantage plans, and that's an interesting area. Now, if you read the MSP, the Medicare, which is Part C, Medicare Advantage plan, would like you to believe as a plan that they have the same rights of recovery on the conditional payment situation or a lien situation as any other, as Medicare does. They would like to avail themselves of the Medicare stick, so to speak. If you read the MSP carefully, it's not a shall requirement on the lien, it's a may requirement on the lien. So I firmly believe that Part C is a lien on a recovery, but it's more controlled by the contract of that individual Part C plan than through federal enforcement, for lack of a better phrase. The contract will control the type of recovery efforts that the Part C can take, depending on who it is. Again, Part C would like you to believe that they have the same rights that Medicare has. I disagree with that. There's also not a requirement, and there's not a mechanism by which these can be resolved through the federal government. On conditional payments, the government has the MSPRC, which is the Medicare Secondary Payer Recovery Center. There's no such thing for Part C, and there's also no requirement to notice the Part C once a case settles. So there are not the same enforcement mechanisms placed for Part C. I liken a Part C lien to a state or contract type lien as opposed to a federally mandated and recoverable lien. I hope that answers your question.
Okay, quick question here. I'm trying to settle a motor vehicle accident with a knee injury. My client was born in 1945, making him Medicare eligible, and settlement will be less than $100,000. There's a 50% chance of having knee replacement at some point in the future. Orthopod says the total medical costs in today's dollars are approximately $20,000. The client is eligible for no-fault medical, approximately 14 left available. What needs to be done as far as Medicare is concerned? Let me take first stab at that. When we're talking about achieving absolute Medicare compliance, we're, of course, and Russ has talked about two separate and distinct moving parts. Number one, past interests represented by conditional payments made from the date of injury to the date of settlement. And number two, future interests represented by payments made by Medicare from the date of settlement going forward, the ones we don't know about. We don't have a crystal ball. So only when both interests are properly addressed do you have absolute Medicare compliance. To satisfy the past interest, obviously you're reimbursed, but to satisfy the future interests, the claimant should determine whether a Medicare set-aside is appropriate. And a Medicare set-aside is appropriate in a liability case if, for example, the settlement release contains a definite allocation to future meds, or there's a jury verdict form containing a line for future meds. Because this question deals with an MVA and no known workers' comp component, at least that I see, unless the settlement release contains a definitive allocation as to future medical. Russ, what do you think about the need for an MSA?
Right. Well, in a circumstance like that, I mean, you've got somebody. There's no similar reasonable expectation test like there is in workers' compensation in liability. There's no analysis that should apply that says, well, this person may be eligible within the next 30 months. The liability rules are sort of ill-defined at this point. In a circumstance like this, you have to make a determination as to what CMS would do with it when it gets reported. If you don't have a reasonable expectation of Medicare eligibility, sort of that first analysis to suggest that an MSA is necessary may be removed from your scenario. The question is when this is a reported event, assuming that it settles, within the next 12 months, makes a determination as to whether, when CMS opens their file, whether they'll assume that their interests weren't protected. I think you can make a reasonable argument under those circumstances that no Medicare eligibility and what a settlement for what CMS considers less than significant dollars, which they seem to suggest is about $250,000, may suggest that a formal MSA is not necessary. I think what you may be constrained to do by good faith is to set aside that $20,000 that the orthopedist said would be appropriate for future medical care. And
I would say even if there is no MSA needed, it might always be good practice to document your file, memorialize the fact that you took Medicare's interest into consideration. Ways of doing that: insert Medicare-specific language into a release, showing that you've at least considered it. Things of that nature too.
Right. So formal MSA, probably not. Something less formal regarding a set-aside account would probably be good practice. I agree.
All right, last question here. What if state and Medicare fee schedules differ?
In a workers' comp context, that depends on how it's projected. Typically, Medicare will default to what they consider as Medicare charges. When you're projecting out future medical care, you argue, at least in a workers' comp context, that fee schedule rates apply. They may, the Workers' Comp Recovery Center may be bound by that. They may differ with respect to your calculations. It's always safe. The safe calculation is always based upon the Red Book pricing, which is what the WCRC uses.
Yeah, I might also recommend or suggest if you go to our website, and both websites will be on the page I'll go back to in a moment, and they've been up there, and they're in your handouts. So you can get a hold of Russ or myself via email or through the websites. But if you go to the Matthiesen Wickert website, you can scroll down. There's these insurance resources on the left-hand side. But down here, we have a form, subrogation questions. If you simply fill in a question and click send, you will usually get an answer within an hour. And if it's MSA related, we can get Russ involved too, and we'll be sure to get you an answer that's pretty accurate. And there again are the websites and the email addresses. Both Russ on his website has some rather interesting and informative handouts, articles. There's an article on our website entitled Subrogation and the Medicare Set-Aside, which deals with a lot of what we've talked about here today. So for any remaining questions that you have, I'm sure Russ and I will be happy to address those. We'd like to thank everybody. Russ, I want to thank you for joining us. We have these every month, and you're obviously an expert in what you do, and we really appreciate your participation. Thank you.
It's my pleasure.
All right, everybody. Thank you. This concludes the webinar. I do want to remind you that our next webinar is scheduled for January 25th. It is the incredibly intriguing and informative topic of subrogation investigation in workers' compensation claims, which ironically, we've given a number of times, but we've had just a number of requests for it, so we're going to redo it. Thank you all, and have a great day. Bye.